Case number 109297, Natala v. Natala and Francis.
May it please the court, Tyson Eisenhower on behalf of the plaintiff appellants Larry Natala and Janet Natala Curtis. With the court's permission, I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
Thank you. So this case involves a defeasible term mineral interest that requires production, development, or operations for perpetuation of the interest beyond its stated term. The precise issue before the court today is whether the granting instrument allowed the defeasible term mineral interest to perpetuate by constructive production via payment of shut-in royalty. Long ago in Dual, this court held that the payment of shut-in royalty does not extend a defeasible term mineral interest because shut-in royalty is not the equivalent of production, development, or operations. And really, this is a simple rule that should be easy to apply. The lower courts attempted to distinguish this case from Dual by focusing on the granting instrument's subject to clause. Specifically, the lower courts held that the grantor intended the subject to clause to incorporate the terms of a previously executed oil and gas lease, thereby allowing the defeasible term mineral interest to also perpetuate by constructive production. Now, we obviously take issue with that holding, and today we're asking the court to do 3 things. First, reverse the lower courts because the subject to clause is not an incorporation provision. Second, apply Dual because Dual is the applicable case law. And third, declare that the defeasible term mineral interest terminated under Dual. To understand our argument, we first need to look at the subject to clause. And for the court's convenience, the subject to clause can be found in the appellant's brief at page 2. It's also in our supplemental brief at page 2. So if you have either of the yellow briefs, you can turn to page 2. There's a block quote, and that's the subject to clause. So it's well settled in Kansas that the intention of the parties is to be deduced from the plain, general, and common meaning of the instrument's terms. And words cannot be written into an instrument that important intent that wasn't expressed by the parties. And so when we're looking at the subject to clause in this case, we need to give that clause its plain, general, or common meaning. Now, I'll be honest, I haven't found a Kansas case that directly opines on the traditional or common meaning of the subject to clause as used in this context. I have found an ample amount of persuasive authority that supports our position that the subject to clause is not an incorporation provision. The first example of persuasive authority would be case law from other jurisdictions, and specifically Texas. If you look at our supplemental brief, we cite 2 Texas cases, the first being Coconut. And in Coconut, when addressing a subject to clause identical to the subject to clause in this case, that court stated, and I quote, "The subject to clause, with above covers and includes provision as a part thereof, merely refers to and limits the granting clause so as to protect both parties under the addendum and warranty clause in the last paragraph of the deed here." And this makes sense. This is what we've argued since the district court level. The subject to clause is simply a notification provision that protects the grantor from breach of warranty. The second Texas case is the Investors Royalty Company case. It's an important case because it's basically identical to what you have before you today. In that case, there's identical facts, and the parties make substantially similar, if not identical, arguments to the arguments that you're going to hear today.
On the identical facts point, counsel, in Investors Realty, was it the same situation in terms of the order of the lease and the deed?
Yes, it was, and I would encourage the court to read over that opinion. It's only 3 pages, and they lay out the facts nicely. It's a short, sweet, to the point opinion, and it directly supports our position that the subject to clause is not an incorporation provision. Specifically, the court found that the subject to clause is not an incorporation provision, it's not a granting provision, and it has no effect on the duration of the grant. And because there was not actual production in that case, just like our case, the court declared that the defeasible term mineral interest terminated by its express terms. Another example of persuasive authority would be the oil and gas law textbook that I happen to use in law school. And I've quoted the authors of that textbook in our petition for review and then in our supplemental brief. The authors, I'm not going to reread the quote to you, but the authors take the same position as the Coconut Court. Again, that is that the subject to clause simply provides protection from breach of warranty. In fact, one of those authors is Professor David Pierce, who you might know, he teaches down the street. Professor Pierce took the time to write an article discussing the Court of Appeals holding in this case. And Professor Pierce's article does a good job tracing the history of this form deed, how it developed, why it developed, and then when he talks about the subject to clause, he references back to the oil and gas law textbook, again supporting our position that the subject to clause is not an incorporation provision. Professor Pierce's article is cited in our supplemental brief. He also makes it a point to point out that if the subject to clause is treated as an incorporation provision, or a rather broad incorporation provision, there is potential conflict with this court's decision in Clausen. Again, all of this persuasive authority supports our position that the subject to clause is not an incorporation provision.
And what's your response to your opponent's citation to Cockrell, also from Texas?
Well, Cockrell actually talks about the Investors Royalty Company. They talk about that. What they're saying with Cockrell might be, you might be able to treat it as a subject to clause, but they specifically reject the argument, you might be able to treat it as an incorporation provision, but they specifically reject the argument that the subject to clause can affect the duration of the grant or the events that could perpetuate the defeasible term mineral interest. We think the court should be looking at the termination clause, and that's because under Kansas law, the event that determines a defeasible term mineral interest must be clearly stated in the instrument creating it. And in this case, the granting instrument expressly requires production, development, or operations for perpetuation. Now we know in our facts, the only potential perpetuating event is the payment of shut-in royalty. But we also know that that doesn't work. This court has already stated in Dual, and I quote, "The payment of shut-in royalty is not the equivalent of production, development, or operations. As the land was not being produced, developed, or operated, the mineral interest was not perpetuated or extended beyond the primary term." It looks like I have a little bit of time, and what I'd like to do is talk about the practical effect of what you're ruling on today. From a title examiner's perspective. Under Dual, a title examiner knew that the payment of shut-in royalty did not extend a defeasible term mineral interest. If there's a holding like the Court of Appeals holding, which actually relied on additional factors, the fact that the granting instrument was executed within a few months of a previously executed oil and gas lease, it was actually 6 months in this case, and then the fact that both of those were executed by the same grantor, a title examiner doesn't know what to do unless they get those identical facts. I guess what I'm saying is that potentially under the Court of Appeals holding, you get a situation where the subject to clause has two different meanings. That can't be the law, and it's definitely not workable for title examiners. So in conclusion, I'd like just to summarize our position. First, the subject to clause is not an incorporation provision. Second, the termination clause expressly requires production, development, or operations for perpetuation of the interest beyond its stated term. And third, because the payment of shut-in royalty is not the equivalent of production, development, or operations, the defeasible term mineral interest terminated under Dual. And for these reasons, and those stated in our petition for review and both of our briefs, we would request that this court reverse the lower court and declare that the defeasible term mineral interest terminated.
Do we have any questions? Thank you, counsel.
May it please the court, Gordon Stull for the defendant appellees Mike Natala and Deborah Francis. Initially, I'd like to respond a little bit to counsel, some of the counsel's statements on their part of the case. The first is the improper reliance on dual to state that you cannot have constructive production by virtue of a lease. The key factor there was not the use of shut-in royalties for constructive production. The key factor was the fact that the lease that was being used was signed by the grantee of the term interest without the approval or ratification of the grantor. Therefore, it was an attempt by the grantee of the terminable interest to extend its effect without the approval of the person that created the term interest to begin with. And that's why that was disallowed. It was because it was a subsequent grantee lease, not because it couldn't be used. In terms of the reliance on the Kokernot case, the difference there is the term in that case was not a term of X number of years and then so long thereafter as production. It was a 20-year term, period. There was no ability to extend it beyond there, and the party in that case tried to use a contorted method to try to get it extended, and the court did not allow that. And we also believe that the investor royalty case is not applicable to support the appellant's position, and for the reasons that we've stated at length in our supplemental brief.
One of the reasons, though, was because the order was reversed, wasn't it?
Right.
And do you concur now with opposing counsel that the order in Investors Realty was the same, the order as between the lease and the grant of the term?
Quite candidly, I can't recall that specific fact without looking at that again.
Okay.
This is really just a case on determinable interest. It has an oil and gas aspect, but it really involves any kind of determinable interest. And the rules of law used by the court in making their decision would be used in any kind of interest, no matter how it was created or what the subject matter was of it. And so we think that the focus in this case on the oil and gas part is really kind of a distortion of what the case ought to be and how this court ought to rule. What has to happen in all these cases is that the court has to determine the intent of the parties from the entire agreement, not from the granting clause or the termination clause, but the entire agreement. The appellant asserts that this is a case of great importance to title examiners. And that's because they say in the brief there's thousands of these documents out there, and there's going to be an unbelievable mess if this case is upheld. And that it has broad implications. The fact of the matter is that there are a lot of sale of oil and gas royalty documents of record across this state. But the real fact is that all of those documents are not the same. All of those documents have probably been on record for 50, 60, 70, 80 years. And they're about the same as all printed leases are the same. They're just not. And you have to look at every one. So nobody can quantify or say how many leases or documents would be affected by this case. It's just pure speculation. And as to the argument that this is going to affect oil and gas title examiners, that also is not correct, because it's not possible to know what any given examiner would decide looking at one of these as to what their opinion would be under the facts that they're looking at as to whether or not there would be a termination. And the real problem with the argument is how this case got here. A title examiner looked at this situation and said, I don't know the answer. He didn't decide, oh, this is not terminated or this is terminated. There was a gap apparently in the law from his opinion. Greg Bauer from Great Bend, a very capable oil and gas title examination lawyer. He says this needs to be suspended till this gets decided. He didn't say that it's terminated or it's not terminated. He said, we need to get this resolved. So therefore, there isn't a great sea of belief out there amongst the oil and gas examiners that there can only be one determination here. We assert that the Court of Appeals was correct in the way they handled this case. They used the appropriate law for determinable interests, and they used the right rules of construction, and they came to the right decision.
Counsel, if I could just interrupt you there and ask what seems to me to be a fundamental question. If this court were to agree with your opposing counsel's argument that we cannot consider the terms of the lease, in other words, we don't read the terms of the lease into the contract at issue, does that end your case, or do you still think that you have a theory on which you can prevail?
Well, I think we do, because
I'd like you to explain that or talk about that a little.
okay, first of all, that gets down to their argument that they're dealing with the subject to clause. It has the word subject to in it, but it's different than the subject to clauses I know from my title examination history. Most of the subject to are after the grant, and then it is subject to easements, restrictions, right-of-ways, reservations, etc. of record. End of story. This subject to clause is very specific, and it's really not a subject to, it's an incorporation clause, and it's an assignment clause. It incorporates the terms of the lease, and it assigns rights in the lease to the grantee. But to answer your question, even if you just had a subject to clause that said subject to oil and gas lease of record, I think you would have the same thing. Because by doing that, you say, I don't know anybody who examines title and sees the subject to line and says, well, there's a number of things that, well, that's okay, that's just there for warranty purposes. We don't care what that says. No, you get them and you look at them, because you're going to tell your client, you're taking this property subject to it, good, bad, or indifferent. The rights in that are subject to are impactful on you, so you got to know what's in there. So I guess our argument that would be, even if it just said subject to, it was subject to the terms of the oil and gas lease, and the instrument it was an assignment of the rights under that lease, which included the shut-in rental provisions. So
you're relying, however, on the lease. That's the crux of your argument. You're not arguing that taking the terms of the contract in a vacuum, that somehow you can still claim that constructive production extends the interest.
No, I don't think you can do that, because I don't think you can take any, unlike they want to take the termination part and say, just look at that. And even if they try to do that, that doesn't help them, because it's vague. It's vague. It just says production. The lease says production developed or operated. In the argument, he mentioned whether it's continued by production or developing or operating, but the grant didn't say that. It's ambiguous. What does production mean? In one of these cases, I believe it's the investors, it said actual or commercial production, paying quantities. There you've quantified it. Clearly, payment of shut-in royalty is not production in paying quantities. What they want you to do is to add language to the grant assignment. They want you to ignore the terms. In their brief, in their supplemental brief at page 8, they said if the granting parties wanted a defeasible term mineral interest to perpetuate via constructive production, then this must be expressly stated in the granting instrument. Now, they don't say in that brief, they didn't say in the granting clause. They said in the granting instrument, and that's correct. You look at all of it. And in fact, it did say that. It said you're incorporating it by reference all the terms. And that clause, if I may, it says, said land being now under an oil and gas lease acquired and executed in favor of, as appears of record, and that was both the grantor, it is understood and agreed that this sale is made subject to the terms of said lease, but covers and includes 1/2 of all oil royalty, gas rental, or shut-in rental, or royalty due and to be paid under the terms of said lease. If they intended for this lease or this term interest to end if there were shut-in royalty payments or a shut-in, why would they have assigned them shut-in rentals? They said, you get the shut-in rentals. If it was over with, you wouldn't be giving them the shut-in rentals. Clearly, you could argue that if it was just during the primary term, but it's not limited to that. The shut-in past the primary term. And there seems to be an assumption that grantors want to see these defeasible interests terminated, that they just can't wait for them to be over. Well, that may be so if you have a sale. They're usually either under a sale or a gift or inheritance. And that may be so under a sale. They might say, oh, yeah, I'm going to get this back. But when you've got one that's not that, we don't know for sure how interested that grantor is. These were transferred to these people, and we have to assume, because there's no language different in the instrument, that the grantor wanted these people to enjoy the benefit of this as long as they could. And the language of the grant as found by the trial court and the Court of Appeals is such that that could happen. What they want you to do is pretend that some language is in that grant deed or grant instrument that's not there. To achieve their purpose, they want you effectively to add, either by some legal decree or by some inference, that the oil and gas lease that's referenced there, and the shut-in royalty that's referenced there, and the payment of shut-in rentals that's referenced there doesn't really exist or really apply. That you just pretend that's not there. Just focus on the word terminate if there's no production. Don't worry about the rest of it. The burden for terminating a term interest should lie on the person who wants it terminated, not the other person. And it should be strictly construed in favor of its continued existence, not its forfeiture. The law of, I remember hearing this in law school. I mean, the law abhors a forfeiture. You wonder, what does that mean? That's what this means. You don't use something frivolously to terminate somebody's property interest when there's a basis for confirming it. And that's what we have here. If they wanted this to say what they wanted to say, I have suggested language, and that is, notwithstanding anything herein to the contrary, payments of shut-in royalties pursuant to the lease shall not be considered production for purposes of perpetuating the interest herein conveyed after the end of the primary term. Well, that would be pretty clear. But they don't have that. And they can't get it added. I mean, I believe it's the Dual case, says we can't add language to your instrument to help either terminate or perpetuate the interest. They can't provide that added information. The message, again, this gets back to, this is a determinable interest case. They're worried about litigation. This case can help maybe stop extra litigation when people don't do a good job of creating these instruments. That would be for them to know that if you're going to create a determinable fee interest, you better be concise and exact and unambiguous about what the terms are for them to end. And that is certainly not the case here, except to say that there is nothing that would terminate it based upon reading the instrument as a total. So we would ask that the Court of Appeals be affirmed. Does anybody have any other?
Any questions of counsel? Thank you, counsel.
Thank you. One of the joys of living in a small town is coming to practice law against kid you see grow up.
You reserve 4 minutes for about.
Justice Breyer, I just want to make sure we're on the same page. The oil and gas lease and investors royalty company was executed on April 17th, 1940. I don't believe the court gives a specific date on the granting instrument, but it does use terms like later, or is executed later in time. So that would answer your question. And Justice Stiegel, if we can get back to the subject to clause, you are correct. If the subject to clause is not an incorporation provision, we win. And we've talked about intent.
Counsel, do you agree with the argument that we just heard that in the royalty contract, the term production is ambiguous?
Absolutely not. Dual solved that problem. Dual 100% supports the position that the payment of shut-in royalty, constructive production, is not enough to perpetuate a defeasible terminal interest. I do want to get back to how their authority for the proposition that the subject to clause is an incorporation provision is 17A CGS on contract section 402. Section 402 has never been cited by an appellate court in Kansas that I'm aware of. Also, the thrust of section 402 is the intent. The parties must clearly express an intent to incorporate for incorporation to occur. We've talked about intent already. Intent is to be deduced from the plain, general, and common meaning of the instrument's terms. We've also provided the court with ample persuasive authority, showing that the subject to clause is not generally construed as an incorporation provision. Now, I'm confident with our cases, Coconut and Investors Royalty, but I would say if the court is looking for more authority, I EG'd the Coconut case because I wanted to avoid a long string cite in our brief. You could, however, pick up a words and usage book, look up the subject to clause, and you're going to find a handful of cases that say exactly what Coconut says. And Coconut, he made a point to make a distinction between the subject to clause in a general warranty deed and the subject to clause in this deed. And that is a valid point. But the cases that I have cited apply to the subject to clause identical to the one in this case. So with that, I think unless the court has any further questions, we'll go ahead and submit our case.
I have one. Counsel Duran just mentioned the shut-in rentals provision, and I'm looking at it on the deed. And how do you answer that? Because it clearly provides that the grantee gets 1/2 of the money rentals that are paid to extend the term of the lease. And so
I do have
why
the answer
wouldn't that, I mean, why would you have that provision and still say that it terminates at the end of the original lease?
Okay, I do have an answer for you. If we want to look at the assignments clause issue, which is what they raised in their supplemental brief, first time we've seen it. But if you want to look at it, it's also an incorrect answer. The assignments clause issue, what we really need to do is look at the we need to look at the shut-in royalty clause basically under the oil and gas lease from kind of like a bundle of sticks analysis. As lessor, I have a stick, and let's say Justice Biles, lessee, you have a stick. And my stick entitles me to the payment of shut-in royalty. So if you exercise your right to shut in, and your stick entitles you to shut in and potentially perpetuate by constructive production. Now I can assign my right to that payment of shut-in royalty, and you can surely assign your right to perpetuate. But I can't assign your right to perpetuate, and even if I can assign your right to perpetuate, it only relates to the oil and gas lease. So as far as the assignments issue, again, it was just recently raised, but I still think it's an incorrect answer to the problem.
Any more questions?
So that clause applies only to the rentals that occur during the term.
That's right. So long as the defeasible terminal interest is in existence and hasn't terminated, they would be entitled to that.
I see no further questions. Thank you, counsel.
Thank you. I
Thank
appreciate
you
the
both.
opportunity to be here.
Thank you both for your arguments this morning. Court will take this matter under advisement.